Hello everyone, welcome back to Law on Obligations and Contracts. Previously, we have started discussing about extinguishment of obligations. First, we discussed about payment or performance. But for this video, we will discuss the second mode of extinguishing an obligation, which is the loss of the thing due. So when is a thing considered lost? Under the law, it is understood that a thing is lost when it perishes, or goes out of commerce, or disappears in such a way that its existence is unknown or it cannot be recovered. That is provided for under Article 1189, paragraph 2. So when you say that a thing is lost, it doesn't mean that the thing's physical existence is unknown. It can also be considered lost when the thing goes out of commerce, meaning to say the thing can no longer be the subject or the valid object of commercial transactions. And therefore, that particular thing, although did not lost physically, but since it cannot be the proper object of valid transactions, then it is considered lost under the law. Or when the thing perishes. For example, the thing is a perishable goods, like a food. So if a food, although physically in existence, but since you can no longer eat that food because it had already perished, then that thing or that food is considered lost. Or the thing may be lost if it physically disappears. Meaning, hindi mo na siya mahanap in such a way that its existence is unknown or it cannot be recovered. So these are the instances wherein you can say that a thing is considered lost. Now, what are the requisites for the loss of the thing due so as to extinguish the obligation? Number one, the obligation is to deliver a specific or determinate thing. When you say specific or determinate thing, it means that the thing can be physically segregated or particularly identified from all others of the same class. Say, for example, a Toyota Vios car color red with plate number 1234. The Toyota Vios car color red with plate number 1234 is considered a specific or determinate thing because you can physically segregate it or you can particularly identify it from all others of the same class because of its plate number. Because each vehicle has its unique plate number, which is not the same, from other vehicles, although of the same kind, like Toyota Vios. Second requisite is that the loss of the thing occurs without the fault of the debtor. Because if the thing was lost because of the fault of the debtor, then that particular loss will not extinguish the obligation. So the debtor should not be at fault when the thing was lost. And third, the debtor is not guilty of delay, meaning to say the thing was lost when it is not yet due to be delivered. So if the debtor is already guilty of delay, meaning to say, nag-due na yung obligation to deliver or nag-due na yung obligation to do, but the debtor failed to do so or the debtor failed to deliver his obligation, and then thereafter the thing was lost or the performance has become impossible, then even if the thing was lost without the fault of the debtor, but if it is attributed by delay, then the loss of that thing will not extinguish the obligation. So let us discuss the general rule. The law says that the loss of specific thing or the loss of determinate thing without fault of the debtor and without delay will extinguish the obligation. So kapag walang fault si debtor at walang delay, at ang thing, subject of the obligation is a specific thing or a determinate thing, kapag yan ay nawala, kapag yan ay nawala, ibig sabihin, extinguish na ang obligation. But there are exceptions to the general rule, meaning to say, even if the thing is a specific thing or a determinate thing, and even if the thing was lost without the fault of the debtor and without delay, still the debtor has the obligation, or still the debtor is liable under the following exceptions. Number one, when the law so provides. If the law says that even if the thing was lost without the fault of the debtor and without delay, you are still liable. So we can't do anything about it because the law says that you are still liable. Second, when the stipulation so provides, it means that if the parties agreed that even if the specific thing was lost without the fault of the debtor and without delay, the debtor is still liable. So, since that is an agreement, then that will prevail. Third, when the nature of the obligation requires the assumption of risk. So you look at the nature of the obligation in order to determine if the debtor will still be held liable even if the thing or the specific thing was lost without his fault and without delay. And when the obligation to deliver a specific thing arises from a crime. So even if the loss of that specific thing was not due to the fault of the debtor and it was not attributed by delay, if that specific thing arises from a crime, a commission of a crime, then the law says that you are still liable by way of exception to the general rule. Now let us discuss loss of generic thing. Earlier, we discussed that if the thing lost was a specific thing, and if that loss is without the fault of the debtor and without delay, we said that the obligation will be extinguished. What about the loss is about a generic thing, meaning the thing cannot be separately segregated or particularly identified from all others of the same class? So this is governed by Article 1263 of the Civil Code, which provides that in an obligation to deliver a generic thing, the loss or destruction of anything of the same kind does not extinguish the obligation by the principle of genus never perishes or genus non quam peruit. So if the thing is a generic thing, even if it is lost without the fault of the debtor and without delay, the law says that it will not operate to extinguish the obligation. Andun pa rin yung obligation kasi yung thing is generic. So, meaning to say, it is important to determine whether the thing is specific or generic before you can decide if the loss will operate to extinguish the obligation. So the rule says that if it is a specific thing and lost without the fault of the debtor and without delay, the thing is extinguished. But if it is a generic thing, its loss even without the fault of the debtor and without delay will not extinguish the obligation. So remember the principle. Now let us illustrate. Number one, S promises to deliver 100 gallons of rice to B. The 100 gallons of rice which S intended to deliver were lost in a flood. Now the question is the obligation extinguished? The answer is no. Why? Because take note here that the 100 gallons of rice is a generic thing because you cannot separately segregate it or particularly identify it from all others of the same class because it only refers to 100 gallons of rice. It doesn't say that this specific 100 gallons of rice. So therefore, since the thing subject matter of this obligation is a generic thing, even if it was lost through a fortuitous event, the flood, the obligation remains. So S is liable to B because his obligation is to deliver a generic thing. And it can still be paid from other sources. Meaning to say, even if the 100 gallons of rice were lost due to flood, S can still replace them with another 100 gallons of rice because this kind of thing is a generic thing. Now, let us go to the second problem. Suppose the obligation of S is to deliver 100 gallons of rice from the harvest made by him, and such harvest is completely lost or destroyed. Is his obligation extinguished? So let us analyze the problem. Earlier, we said that in the first problem, the thing is a generic thing. That's why the obligation remains, even if the 100 gallons of rice were lost due to flood. But take a look at the second problem. Take note here that the 100 gallons of rice should come from the harvest of S. So, because of that additional data or additional information, the 100 gallons of rice here becomes a specific thing. Therefore, the loss of the harvest will operate to extinguish the obligation of S. Because the 100 gallons of rice are specific things that come from the harvest made by S. Yes, the obligation here is extinguished because the rice stipulated to be delivered is confined to a particular class and may thus be considered a determinate thing. So that is the answer to the second problem. Now, what if there is a partial loss of a specific thing? Meaning to say, the specific thing was not entirely lost. So, this is governed by Article 1264, which provides that the courts shall determine whether, under the circumstances, the partial loss of the object of the obligation is so important as to extinguish the obligation. So, let us have an example. S oblige himself to deliver to B a specific race horse. So there is no need to determine here whether the thing is a specific or generic thing because the problem already provides that the racehorse is a specific racehorse. So therefore, we can say that this is a specific thing. So let us say, for example, the horse met an accident as a result of which it suffered a broken leg, and the injury is permanent. Here, the partial loss is so important as to extinguish the obligation. Although the horse did not die or the horse was not lost completely, but because of the injury suffered by the horse, the broken leg, which is a permanent injury, then it may be considered that the partial loss is a complete loss so as to extinguish the obligation. Take note here that in case of partial loss, the court is given the discretion in case of disagreement between the parties to determine whether under the circumstances it is so important in relation to the whole as to extinguish the obligation. In other words, the court will decide whether the partial loss is such as to be equivalent to complete or total loss. But let us say, for example, the loss was due to the fault of S. So, will the obligation be extinguished? The answer is no. S here will be liable to pay the value of the horse with indemnity for damages. for example, the purpose of delivering the horse is not for race purposes. Let us see, for example, the purpose is to be slaughtered by B. Ihawon ni B ang horse, no? Dili siya pang racing. What if that is the purpose for the delivery of the horse? And the horse was injured. And the injury was permanent. So what is the effect and the obligation? Okay? Since the injury is not important, is not that important because after all, B will slaughter the horse. Papatayin din naman niya yung horse. So the injury is clearly not important. So even if there was fault on the part of S, he can still deliver the horse with liability for damages, if any, suffered by B. Now let's go to the presumption of fault. Under Article 1265, whenever the thing is lost in the possession of the debtor, it shall be presumed that the loss was due to his fault, unless there is proof to the contrary, and without prejudice the provisions of Article 1165. This presumption does not apply in case of earthquake, flood, storm, or other natural calamity. So let us have an example. D borrowed the car of C. On the due date of the obligation, D told C that the car was stolen and that he was not at fault. Is D liable? That is not enough to extinguish this obligation. The mere fact that C alleges that he is not at fault is not enough to extinguish this obligation. Because under Article 1265, it is presumed that the loss was due to his fault. Hence, he is liable unless he proves the contrary. So, what does this Article 1265 mean? It means that if the thing was lost in the possession of the debtor, it is presumed na siya yung may kasalanan kung bakit nawala yung thing. So, since there is a presumption na siya ang may kasalanan, the law requires that he should provide proof if he wanted to prove that he is not at fault. Again, kapag yung thing nawala sa kamay ni debtor, may presumption na siya ang may kasalanan. Para ma-prove niya na wala siyang kasalanan, the debtor should provide evidence or proof to the contrary. Kaya, hindi enough na sabihin ni debtor na wala siyang kasalanan. Kailangan magbigay siya ng pruweba na wala siyang kasalanan. Yun ang ibig sabihin ng first paragraph ng Article 1265. However, may exceptions to the rule. Even if the thing was lost in possession of the debtor, if the loss was due to earthquake, flood, storm, or other natural calamity, then the presumption will not apply. Just remember the general rule and the exceptions. Now, let us proceed to the next problem. Suppose the house of D was destroyed because of fire. It is admitted that there was a fire and it was accidental and that the car was in the house at the time it occurred. Meaning to say, nang dahil sa sunog, nasunog din yung car. And it was proven or admitted that the fire was accidental only, hindi kasalanan ni C. Hindi kasalanan ni D. Is D liable? Here, D is not liable unless C proves fault on the part of D. So, bumaliktad yung burden of proof. Kanina, sabi natin, yung presumption of fault nasa debtor. So, liable siya kapag hindi niya ma-prove na wala siyang kasalanan. But, if the loss was due to earthquake, flood, storm, or other natural calamity, including fire, then the presumption will not apply. Therefore, it is on the part of C that should prove that D is liable or D is negligent. Okay? Now, let's talk about obligations to do. Earlier, we discussed about loss of the thing in an obligation to give. Meaning to say, in an obligation to deliver a thing, whether movable or immovable. But what if the obligation is an obligation to do? Meron bang loss in an obligation to do? Nawawala ba yung obligation to do? So, let us see. Under Article 1266, the debtor in obligations to do shall also be released when the prestation becomes legally or physically impossible without the fault of the debtor. So, there are two instances here that says that if these instances will happen, then the obligation to do may be considered lost, provided it is without the fault of the debtor. So there are two kinds of impossibility in obligations to do. Number one is physical impossibility, which takes place when the obligor dies or becomes physically incapacitated to perform the obligation. Obviously, if the obligor dies, he can no longer perform the obligation. Therefore, there is physical impossibility. The second kind of impossibility is legal impossibility, which occurs when the obligation cannot be performed because it is rendered impossible by provision of law, although physically it may be possible of performance. Take note here that in legal impossibility, there must be a law or an order of the court or an order of competent government authority. So if that is the case, there would be legal impossibility. Now, let us have an illustration. D obliged himself to paint a picture of C to be finished within a month. 1 week after the obligation was constituted, D met an accident, as a result of which his arms were amputated. So what will the effect now of that accident? Here, the obligation of D has become physically impossible. D is therefore released from his obligation by virtue of Article 1266. Let us go back to Article 1266. What does it say? It says, the debtor in obligations to do shall also be released. Ayan. Ma-release daw siya sa liability niya under the obligation kapag yung prestation becomes physically impossible without the fault of the obligor. Now, let's go back to the problem. Take note here that there was an accident, meaning to say, walang fault si debtor. Nang dahil sa aksidente, na-amputate yung kanyang arms. And para makapinta siya ng picture ni C, kailangan niya yung kamay niya, yung arms niya, di ba? So therefore, because of that accident and because of his injury, he can no longer perform his obligation and therefore, he is released now from his obligation because of physical impossibility. However, the rule does not apply where D bound himself absolutely to finish the painting irrespective of whether his failure is caused by unavoidable accident or for any reason, in which case he shall be liable to pay damages for non-performance. What if, for example, sabi ng D, gawin ko talaga yan kahit na anong mangyari. Kahit na mamatay ako or mabalda ako, ganyan. So, dahil nag-promise si D ngayon na i-perform niya yung obligation, absolutely, kahit na mayroong mga unavoidable accident or for any reason, then even if D met an accident and even if his arms were amputated, then he is still liable to perform the obligation. Now, let us have an example of legal impossibility. D agreed to construct a commercial building for C. The government refused to issue a building permit because the area has been declared by law as a residential zone. Ayan, kasi under the law, bawal ka kasi mag-construct ng commercial building on a residential zone because that zone should be used for residential purposes, meaning dwelling ng mga tao. So, bawal ka mag-construction ng commercial building. So, the obligation of D is therefore extinguished because it has become legally impossible. Here, the performance of the prestation is directly prohibited by law. Now, let's go to difficulty of performance governed by Article 1267, which provides that when the service has become so difficult as to be manifestly beyond the contemplation of the parties, the obligor may also be released therefrom in whole or in part. Take note the phrase manifestly beyond the contemplation of the parties. So, in order to understand this article better, let us have an illustration. D agreed to construct a road near a mountain. A very strong typhoon caused an avalanche, making the construction of the road dangerous to human lives, which was not foreseen or contemplated by the parties. In this case, D may be released in whole or in part from his obligation to continue with the construction because the performance has become so difficult as to be manifestly beyond the contemplation of the parties. Now, we mentioned earlier that as one of the exceptions to the general rule, if the specific thing proceeds from a criminal offense, though the thing was lost due to fortuitous event or without fault of the debtor and without delay, the law says that the obligor or the debtor is still liable for the obligation, no? or for the damages, no? For the value of the thing lost and damages. So, under Article 1268, when the debt of a thing certain and determinate proceeds from a criminal offense, the debtor shall not be exempted from the payment of its price. Take note, kahit na yung thing is determinate or specific, kapag yan ay nag-proceed from a criminal offense, then it will not exculpate or it will not exempt the debtor from liability. Whatever may be the cause for the loss, whether it be lost due to fortuitous event or due to his fault, unless the thing having been offered by him to the person who should receive it, the latter refused without justification to accept it. Now let us have an example. D stole the jeep of C. Here, D has an obligation to return the jeep to C. The obligation arises from an act punishable by law. Even if the jeep is destroyed without the fault of D, he shall be liable for the payment of its price. The exception to the rule is when C is in mora accipiendi. In either case, D is liable if the loss is due to his fault. Okay? So what is mora accipiendi? Meaning to say, dineliver na ni D yung jeep, but C will not accept. So that is mora accipiendi. Delay in the acceptance of the thing. So, dahil hindi tinanggap ni C yung jeep, isinauli na nga ni D, tapos ngayon, after niya isauli sana, nawala yung thing, then D will not be held liable. Kasi kasalanan ni C, hindi niya tinanggap. But if the loss was due to the fault of D, even if C refuses to accept the thing, then D will still be held liable. Kasi kasalanan niya kung bakit nawala. Dapat, yung pagkawala is through a fortuitous event. Or it was not through the fault of the debtor. Now, let's go to the last provision of this chapter, loss of the thing due. Right of creditor to proceed against third persons. Now, Article 1269 provides that the obligation having been extinguished by the loss of the thing, the creditor shall have all the rights of action which the debtor may have against third persons by reason of the loss. So example, S obliged himself to deliver to B a specific horse. The horse is lost through the fault of a third person, T. While the obligation of S is extinguished and he is not liable to B because the horse was lost without his fault and without delay, and that horse is a specific horse, then the obligation of S here is extinguished. But although his obligation is already extinguished, the creditor, B, can still go against the third person. Who is the reason for the loss? T. In this case, it was T. So the law protects B by giving him the right to bring an action against T to recover the price of the horse with damages. Okay? That ends our discussion for loss of the thing due as a mode of extinguishing an obligation. Thank you for watching and see you on our next video.